3002441. State, Mr. Hagman, where are we at today?
We met with Your Honor, all the councils met with Your Honor directly before this court hearing. There's a couple lingering things that we're trying to get with the defense counsel. We've all agreed on November the 6th as a date to come back to this court with an eye toward a couple things. The first is the entry of a scheduling order that would set a trial date certain for this case. And in that vein, you asked the state about the federal indictment, and it's the intention of the state not to let that federal indictment slow us down, but rather to proceed forward. We feel like we've been litigating this matter in court for the last 6 or 7 months, and we do not want delay. We'd like to proceed toward conclusion on this case, irrespective of that federal indictment. So November the 6th for the parties, we'll be communicating with them, getting them some stuff, and we will report back to the court on that day with hopes of a scheduling order and a trial date.
Any of the defense counsels wish to be heard?
No.
Okay. So we will go ahead and set this matter for a report on November 6th. On that day, we are anticipating entering a scheduling order. You all can bring your calendars with you with the eye towards setting a trial date in this matter. And we will, if there are any outstanding discovery issues or things that you're needing to get from the state, you can go ahead and make sure those requests are in so that we cannot have that cause any delays. We have some pending motions on motions to sever at this time. So if you are not a party to these motions, we will excuse you at this time. We will see you back on November 6th. All those that are involved in these motions, please stay. So we'll go ahead and excuse those defendants.
Thank you, John.
Thank you. Judge, can the defendants that are remaining have a seat for the rest of the proceedings?
Absolutely. We have 2 motions to sever filed by Mr. Brown, Mr. Perry, in this matter.
Yeah, the first one was mine.
Oh, I'm sorry, I didn't see you on that screen.
I got to mine in the morning. You did yours in the afternoon.
Okay.
You're hidden, Mr. Zuma.
Yeah, I'm doing the best I can.
So we have the 3 defendants here on their motions. Being that many of the points are similar in nature, rather than handling individually, I would allow each of the defense attorneys to make their positions before, and then we'll allow the state to respond as a whole rather than just individually, unless that is a problem for the state.
I think that's fine, Judge. We filed one response to cover all the motions.
All right, so we will go ahead. We'll start with Mr.
Mr. Perry and I kind of coordinated, flipped a coin. He's going to go first, if it's okay with Your Honor.
Yes, sir.
Then I'll go second, and then Mr. Bowman bats clean up.
Thank you. May it please. Your Honor, as the court is aware and has just stated a few months ago, filed motions to sever in this case. And in the motion to sever, we relied heavily on the Harbison case and the Harbison factors. Those factors being the types of, the number of defendants, the number of counts, complexity, et cetera, et cetera. And as the court is aware, having read the case, those aren't bright line factors, but in this particular case, I would like to look at number 3, the complexity of the case. Your Honor, I would tend to say that this is probably one of the most complex cases that has rather simple facts, and the accusations contained in the indictment on their face are rather simple. But once the court looks at the factors that would, in my opinion, favor severance, I think the factors are kind of complex. On behalf of our defendant, Tadarrius Bean, we're stating that we're placed in an awkward position from the gate, in so much that there are two different scenes that are involved. The court just talked about, and we've discussed in previous settings, the fact that there are video and that there have been video discoveries that have been tendered. And we've looked at various videos, and those videos established, as I laid out in the memorandum, that there appear to have been at least two different scenes. The first initial contact scene, and then the second scene. That first scene being at Raines and Ross, the second scene being at the Castlegate corner. Your Honor, if you have read the memorandum that was tendered by the state in response to our motions, they seem to have conceded the fact that that first scene and probable cause was correct. And that in and of itself, at least I tendered to the court, suggests that they have engaged in a severance already of one of the co-defendants. If that first scene has no probable cause issues, has no issues at all, which of course in their memorandum, that is what they say, that goes in direct, I guess, contravening the statements that have been made sometimes publicly about what they thought was offensive. We're fine with whatever they say publicly, but in the forum that we're before right now, it is essential to look at the scenes respectively. And if you're looking at that scene, those two scenes, you have two different perspectives of the officers involved. Unlike other severance motions where we're sitting here saying, hey, this person did this bad, this person did X, Y, Z, that was wrong. I'm not saying that at all. I'm saying that the conduct of the officers fit the situation that was involved that day. But what I am saying is that there was a perspective that was created from the first scene that's separate and apart from the perspective of my client, Tadarrius Bean, which would have arrived at that second scene. His perspective had nothing to do with the errant driving of the officer that got behind a car that evidently from the discovery had been driving at an excessive rate of speed, that goes through an intersection that from the time that he cut his blue lights on had driven some 2 miles before it came to stop at the first scene. That officer and the three officers that would have been involved on the first scene would have had the opportunity to look at and engage in that particular suspect on that scene. They had the opportunity to note how he was sweating, note how he was doing whatever he was doing inside that car. They also had the opportunity to respect the dangers of that person. Their perspective would have been heightened, a more engaged perspective regarding the suspect. And if you have, in looking at the discovery, it becomes clear why the suspect is acting a certain way. Because through the discovery, we've seen what the suspect had. We see the magic mushrooms or hallucinogens. We know the fact that he had a number of substances in his system. And we also know from that first scene, the fact that particular suspect at that time was not complying with the first three officers that engaged him. And so their perspective is different when they arrive to the second scene. Now, Tadarrius Bean only heard over the radio that there was an individual that had been in a conflict on this first scene. Based on that, he goes to the second scene. He engages the person who takes off running on the second scene, and he attempts to apprehend that suspect. That's his whole perspective. So he doesn't know anything about the person that has been tased on the first scene, and the fact that that had no type of effect on him. He has no clue that the person has been pepper sprayed on that first scene, and it has no effect on him. At the time that he's engaging him, he has no idea that this person seemingly had superhuman strength. All he knows is that there was a person who appeared to be tall in nature that fit the suspect description. And when he engaged him, he takes off running. And he, at that time, does what the law says that he has to do. Not that he has an option like I would on the street. If somebody does something wrong, I can just keep walking. He's a sworn officer that has to engage that person, has to grab that arm as he did, and he never struck him. But also, at the time of the apprehension or the attempted apprehension, there was an attempt to put a handcuff on one arm, and out of 53 requests to give the hands so that he could be fully handcuffed, you have a suspect that does not comply. So based on his perspective at this time, this person being combative and not subduing to what the officers have commanded is a danger. And whatever conduct was happening on that scene from his perspective was necessary because fatigue, sweat, all of those things become a factor as the moments become important to the person who, if he lets that hand or arm go, then you have a suspect with a weapon, with a sharp instrumentality. If the other person lets the free hand go, you have a suspect that has gone a mile or so to this scene on foot after all of the combat that has gone on before and has not acquiesced to being placed in handcuffs. So you have the perspective of a person from a second scene. That is a complex, unique set of facts in that the person who has a hand on him is sworn by law to keep that hand right there. At that time, and if you look at even the Department of Justice's use of force continuum that was published in 2009, and that was corrected back in July of 2022, the one in 2022 by memorandum says that the person has to make split-second decisions. And you see in this particular instance, different than those that are other cases where a person comes to the scene at the same time, all three officers or four officers, and after they have the suspect handcuffed, begin to gratuitously beat this person. In this particular instance, none of the officers did anything but assist, setting him up on a car after he's handcuffed. Not one lick, not one kick from anybody. And the other part of that perspective is that as Bean is attempting to get that arm into custody, along with the other officers, all of the activity was within departmental guidelines at that time. In other words, the department says, when you're using strong hand force, kicking, punching is acceptable. And if the person is not compliant, it's in black and white. You don't have a person that's watching two officers come from a scene where they've engaged in this dangerous person from his perspective that pulls a pistol out and points it at it, where he can say, hey, don't do that. No, you have people trying to get two hands complied with a person who we now know has hallucinogenic mushrooms, alcohol, antidepressants, marijuana in their system. And so based on those things, the perspectives here from an officer that was not at that first scene to engage in the suspect, it's only fair that he be adjudged by a jury from his perspective only. It's a different situation where they're coming up and he sees somebody with his knee on a person's windpipe and has the opportunity to say, hey man, don't do that. Don't do that. He might die. He might pass out. Don't do that. In this particular instance, you have an active engagement. And I'm going to go back to a factor that I kind of moved on from, that if you look at the memorandum as submitted by the DA's office, they, in essence, try to change the meaning of count 4 of the indictment, as well as possibly count 5 or 6. And really, there was a letter that was tendered by Mr. Stengel regarding their response, where he indicates that, you know, there are a number of perplexed questions that come from their memorandum. And it's true. In his letter, he says, expect a bill of particulars. There have already been 2 bill of particulars filed because simultaneously we had conversations regarding it, and looking at the indictment itself, it's so confusing because you're naming 2 different counts of kidnapping in essence, but one causing injury, one not causing injury. And you name, while you're naming that, you then say, well, now that we've let one of the defendants go, that we haven't charged him at this point, wasn't even fired from the department until public outcry. But if it's such an issue with severance, why is there a problem with severing Bean, who never struck him, never used any language that would be untoward towards him, never did anything but his job, because he didn't have the perspective of seeing him do all this stuff from the first scene, y'all. And that's what we're asking for. Yes, sir.
Let me ask you this. You keep mentioning the complexity of the situation,
Yes, sir.
but it seems not all that complex when you explain it. What is the ultimate question is, what would make it not possible for Mr. Bean to receive a fair trial by being tried together with the defendant?
And thank you for asking that. It's because the state's sole theory regarding Mr. Bean, seemingly from reading the memorandum, is one of criminal responsibility as it involves count one. Bean's never seen striking the person in any way that other than on the forearm area. And I think this conceded in the point in their memorandum. Well, how can he get a fair trial in a case that's based off criminal responsibility unless the parties have had some kind of engagement by anything, a text? If the original rumors about the case about there might have been somebody dating somebody on the police force or what have you, and this might have been an issue, and you have some sort of text messaging saying, hey, you see this car, we need to stop it, we got a problem with dude, whatever it might be, then I would concede that. And I would say that under the normal, I guess, looking at criminal responsibility, it would apply. In this instance, you have a police officer that has to do his duty. He has to respond to a call. He does not know what the other individuals who have engaged in the suspect have talked about, have had any communications about. So you don't have that normal dialogue or expectation that you would. If Your Honor and I say, hey, we're going to rob a bank, and we talk about it, and one person gives us the idea about it, and you and I go, but I'm the one that goes in, gets the money, but as I'm leaving, I shoot somebody, I think we all have a criminal responsibility about it. Now, in this case, the only person that made a suggestion of doing anything wrong is sitting somewhere, maybe watching this on TV right now. He's the only person that said that he wished something wrong would happen. That person's gone because they severed him from the very beginning. And what we're saying is that Bean he was at a location about 2 miles from that scene. And here's the call, and he's riding with another co-defendant, and they go and do what their job is supposed to do, Your Honor. And that's the reason that I'm saying that it's a more complex set of facts than the standard conspiracy case.
But with the arguments that you're making, again, the ultimate question, as you're laying out your position, as you're laying it out to me just now, how is that position how are you not able to make that position in front of a jury, even with the other defendants there? How is the presence of the other defendants somehow deny you the ability to make that argument?
Your Honor, respectfully, I don't think that their presence necessarily denies the ability to that. I think that if you look at that one, I guess, brick out of the 8 bricks that are laid out with the Harbison factors, that the number, you got 5 defendants, et cetera, and then you have the length of time really that it would take, I think, favors us, because if there was a severed case, you're talking about probably 2 to 3 days per defendant, maybe. So you're not talking about, in other words, something that would just eat up Your Honor's calendar. But I also say that the way that I wrote my memorandum, and I didn't want to do it for the purpose of this hearing out of respect for co-counsel, I respectfully say that if you're not saying that defendant Bean should be separated, then maybe the other 2 defendants with Bean being 2 different scenes could be possibly separated. And I want to be clear with the court. I'm of the position that after having dealt with use of force experts in this case and looking at it, that there's no issues of us saying that we're going to finger point and say this defendant did X, Y, Z wrong. But at the same time, I don't think that it's fair to weigh the proof with 5 defendants based off of 2 having had the opportunity, or 3, if you want to count it correctly, having the opportunity to have engaged in the suspect on this very first scene. I think that's the unfairness, Your Honor.
If we were to do separate trials, wouldn't all of the same proof need to be presented at both trials?
And that's a good question based off of the way that they answered the first, the memorandum. I think the issue with that becomes which one wants to have information from that first scene suppressed and which ones want to have the information from the first scene entered where they are able to explore their perspective. And the reason that I say that, if you got Bean that sees this person after he hears a call come in, that's totally different than what you know and what you have observed about how he's driving in traffic and all this other stuff. And so you have a heightened sense of danger that this person has. Well, why should I have to wait to see which approach we're going to attack, and and not have an appreciation with the differences and that. But I also want to point out to the court, because it did come up earlier, and just because of where we are this week, there's one thing that was tendered by the federal court order, which is that the defendants cannot have communications directly with each other. To me, that would be basically tying everybody's hands. Well, the opposite of tying our hands together. It would be placing us at trial at the same time. People can't have conversation about memory, et cetera, without, if somebody is watching the trial, saying that they're violating that federal court order. So it makes communications, trial strategy, et cetera, a very difficult notion if we are in fact going to trial at the same time.
So, was there anything else, Mr. Perry?
No, Your Honor.
All right. Mr. Dwight.
Yes, Your Honor. Mr. Perry calls it perception, or what people perceive as this case unfolded. Not that that's wrong, but I refer to the state of mind. This is a state of mind criminal case. I mean, they're charged with second-degree murder and 2 counts of kidnapping, to name just a few. So I'm asking the court that after you hear arguments today, if you determine that this is a close case on severance, I'm going to ask the court to review the videos provided to us in discovery. I brought the hard drive given to me by the state to review, because let's face it, we all live in Memphis and we've all heard the media. We've all heard Miss Hendrew and Mr. Birch and everybody else weigh in on what these officers were doing at the scene. We've all heard that, which means jurors will hear that. And if the perception that a jury has, because we all know what the shock was, when those videos were released by the city of Memphis, we all know what the shock was. We all heard from Merrick Garland. We all heard from the TBI director. I'm here to represent Justin Smith and get him a fair trial, to have a jury look at what he did and determine if he committed second-degree murder. That's what I'm here about, for him to get a fair trial. And let's face it, we've got about 2 strikes against us just based upon the media thus far. And they're all right here looking at us as we speak. So I would ask the court, if it considers it a close case, to sever Smith, candid, if I didn't say this, Smith and Bean, Mr. Perry's client, were doing the identical things at the scene, or nearly identical. So the reality of it is, as it relates to Smith and Bean, and then Mills, who roll up, they're in one car and Smith is in his own car. They've got a call saying we have a fleeing suspect who's been tased and sprayed. They have a duty, as has been said, to come apprehend that fleeing suspect. They have no idea if he's a rape suspect, robbery suspect, what he is. They don't know if he's been patted down. They don't know if he's armed. They've got a duty to come to the assistance of the officers who called at the first scene. Everybody can just ignore that first scene if they want. But at the first scene, Tyre Nichols somehow got away from 3 adult cops who sprayed him and tased him. And the spray had 0 effect on him. Experts will talk about what that means. He's a mile away over at Bear Creek. This one, Justin Smith, he's sitting in his car, doesn't have his blue lights on, which explains, by the way, why he doesn't have his body cam on. He's sitting there trying to figure out where he's at. He's looking at Google Maps and all that. This fella is chasing the suspect who matches the description that went out over the radio of Tyre Nichols. He runs from this officer. That's at least twice he has fled from the police. Bean chases him down and tackles him. Now, I want this court, I want the DA's office to take a snapshot in time. At that point in time, has a crime been committed? There's nobody in America that would say that at that point in time there's been a crime committed. That's why I say it goes to state of mind. What was known by these 3 officers at the time they came into contact with Nichols? Well, we talked about it. They had a radio dispatch, fleeing suspect, been tased and sprayed. And a point that should not be missed, this man is accused of intentionally taking part in the killing of Tyre Nichols. But what I haven't heard the media or anybody else say, that when he got that call, he's over at the Family Dollar store on a steel watch, and he hears that Nichols, or the suspect, don't say the name, has been tased and sprayed. His first call is to dispatch at the precinct. If he's been tased or sprayed, roll medical now in case we apprehend the suspect. Obviously, he's not going over there to kill anybody. And that's important, Your Honor, because it's state of mind.
And I understand that, but we're going into a closing argument, and in the sense of where we're at right now, with the position that you're making, with the state of mind, the question is the same question I had for Mr. Perry. How is that argument not able to be made with the rest of the co-defendants?
And I had an answer when you asked Mr. Perry that was a little bit different than his. We have to leave our common sense at the door if we think that one jury can see what was going on once Smith and Bean and Mills are trying to get Nichols handcuffed. We have to leave our common sense at the door when what happens after that is not attributed to these guys. So much so that the DA says they acted as a team to hold Mr. Nichols so that he could be beaten to death. That's their words. They can't get a fair trial, and that's exactly what Zafiro, which is a U.S. Supreme Court case that Harbison looked to. The different levels of culpability, the different levels of involvement of the multiple defendants, and the complexity of the proof. Secondly, the complexity of the proof. This is a murder case, cause of death, instrumentality of the cause of death. We don't necessarily know it was the vicious head blows, as the state says, or kicks. We don't necessarily know that.
But wouldn't it benefit your position more if you were at trial to be able to differentiate, having all the defendants here, all the defendants on the trial, and you'd be able to distinguish what your person did separately than everyone else, rather than have the trial with just your client sitting there and all of the proof being presented with just your client being. I mean, I understand that your position. It seems as though it could be both ways.
If nothing else, I'm honest. I may not be confident, but I'm honest. And your point is actually what my point, Mr. Perry's point was. We'd almost rather have the 3 good, I'm going to call them good guys. I'd almost rather have the 3 good guys in the room with other guys. Okay, I'd almost, because the jury's going to be able to look at, hey, these guys are doing their jobs. You're right, Your Honor. But at the end of the day, I'm going to have to look this man in the eye. And if there is a 1% chance that he gets convicted as a result of that violent video, I just don't know that I can look at his wife and kid that way. And so I would almost err on the side of, I'd rather a jury try these 2 men, maybe 3 men together, than to look at him after the trial and say, man, I think you got convicted because those videos were so horrible of the punches and kicks. That's my fear, Your Honor.
So your present or would be known to the jury at the trial, all of that evidence, all of the things that would go towards a state of mind and that would lead up to that point would still, for the most part, need to be presented in your trial to get us to that point, correct?
Yes, Your Honor, but Zafiro says if the question of the reliability of the judgment as to one of the defendants is called into question, severance is encouraged. And I'm telling Your Honor, candidly, I'm fearful of this man, or maybe these three men, being convicted based upon evidence that really does not apply to them. And that's my concern, Your Honor. I'd rather err on the side of a fair trial for one defendant, even if it takes 5 times as long, than I would to have him sit here in trial based upon what we know the videos show, and possibly get convicted of second-degree murder because, as Mr. Hagerman says, they held him up so that he could be beaten viciously, which I really believe everybody in this room knows not to be true. But I can't risk that with this man. And that's why I'm asking to sever him out. I'd rather take the chance. And for that matter, Mr. Perry and I don't think I'm speaking out of school. Mr. Perry and I said, we'll try these two guys together if Your Honor lets us in one trial. I haven't got to talk to Mr. Ballin, but I don't have an objection to having Mr. Mills in our trial.
Mr. Ballin?
Judge, I'm glad you're sitting down for what I'm about to say. I don't have anything else to say. No, just very, very briefly, I will just rely on our written motion. My very capable co-counsel has made the same arguments that we would make, and I know that the court's time is precious, so we would submit on our written arguments and adopt the arguments that co-counsel has already very brilliantly made to the court. Thank you.
No, I would agree with the court that I'm hearing a lot of argument in terms of potential closing statements that I may personally disagree with, or I may think the jury is going to disagree with, but nevertheless, it sounds like a lot of closing statements rather than reasons to sever the case. I think Your Honor has put counsel on the spot with a couple questions that simply haven't been answered because they can't be, because the facts in this case are particularly simple. They're terrible, they're tragic, they're awful, they're murder and they're kidnapping, but they're pretty simple. It's not a difficult case to understand. The presentation of the case, again, it's a trial. I expect counsel to do their job. It's going to be hard, but the presentation is going to be, at some point, particularly simple. It's press and play on some videotapes and watching what these defendants and the other two defendants did to Mr. Nichols. All that evidence would be presented whether or not one defendant's tried separately or they're tried together. So there's not issues with regard to confusing the jury by playing certain portions of videotape. So it's all relevant evidence that's going to be played in one trial, 5 trials, or whatever else. As part of Mr. Perry's argument had to do with conspiracy. These defendants aren't charged with conspiracy. This is a simple legal concept of criminal responsibility that the juries every day understand and will be board honored about by both Your Honor and counsel at this trial. We all watched on videotape, on television, this thing happen. And it's terrible, but we saw 5 men all wearing the same uniforms, all taking part in a brutal beating, all together at the same time, handcuff him, lay him on the ground where he dies. It's terrible. I expect the trial will be hard because counsels will do their job and they'll be impassioned like Mr. Perry was and Mr. Zumak was in their arguments today. But I haven't heard a single reason why these cases should be severed. I look at the harvesting factors, the ones that have been mentioned. I don't see a single factor that counsels for severance. Number of defendants. This is 5 defendants. I understand that, but this is not a federal drug conspiracy RICO trial with 28 defendants, where we simply don't have room in the courtrooms and it becomes unwieldy. The number of counts charged. This is not a complex indictment. Mr. Perry said it's a simple indictment, and I agree with that. The complexity of the indictment, again, as Mr. Perry said, a simple indictment, and I agree with that. The estimated length of the trial. For the state to prove its case, it doesn't need 5 times the witnesses to prove the case against the 5 defendants. It's the exact same number of witnesses. It's the exact videotapes. So it doesn't extend the state's proof at all to have 5 different defendants. Disparities in the evidence are all alleged to have taken part in the exact same crimes at the same time, wearing the same uniform, to the same victim, caught on the same videotape. Disparities in the evidence or the disparities of the degree of involvement of the defendants. Your Honors put counsel on the spot with regard to that. Of course, these defendants may well argue that it was Officer Martin who's the most responsible in this crime, but that's to their benefit. There's nothing about presentation of this case against these defendants that somehow prejudices the 3 that we have seated before us. Conflicts between the defendants, again, the only thing we have is disparities maybe in relative guilt, but we don't have any conflicts that State versus Inslee or any of the other cases would term compelling prejudice and would require any type of severance. And then all the counsels mentioned, none of them argued today with regard to statements that they gave that maybe inadmissible. Defendants didn't give statements, they don't exist. I don't know why those were mentioned in their motions. I don't think there's a single harvesting factor that counsels for severance. I think we have all watched this crime happen together, 5 people at the same time, wearing the same uniforms, doing the same things, and we should try this case together.
Mr. Harrigan, as far as the situations and circumstances, and as one of the attorneys stated, different state of minds of what was approaching that happened. Why shouldn't that be considered?
Yes, sir. Two things I would say there. The first, evidentiary wise, regardless of whether or not these defendants are tried with Officer Martin and Officer Haley, what happened at the first scene is relevant, it's contextual, and it's going to be evidence that's presented at their trial. Okay, so it's not like the first scene, I'm going to say first scene, y'all know what we're talking about, the traffic stop. It's not that the first scene would never be seen, by their jury. Of course it would. So it doesn't introduce any more proof. Counsel has made reference to something that I've told counsel ever since this indictment hit. The defendants are charged with criminal conduct, murder, kidnapping, official misconduct, oppression, for what happened at that second scene. Okay, so no defendant, state at trial, is not going to argue that these defendants are responsible for anything that happened at that first scene. We're not even going to argue that what happened at the first scene was necessarily criminal or not. We can disagree on whether or not it was. It doesn't matter, because horrible, terrible crimes happened at that second scene caught on camera, and it's that conduct with regard to all 5 defendants that we're alleging is the criminal conduct, the kidnapping and the death and the official misconduct, everything that terrible that happened to Tyre Nichols at the second scene. Given that, what prejudice could these defendants possibly face? They weren't at the first scene, they're at the second scene. Well, all the criminal conduct is at the second scene. They want to argue about their state of mind relative to the others? Fine. There's nothing in the law that prohibits that. They even get to do it with Officer Martin or Officer Haley sitting right next to them, and they can argue relative guilt or whatever it is to their benefit. But there's nothing about a trial with 5 defendants that somehow limits or prejudices their ability to explore state of mind, relative guilt, or anything else.
Is there any response?
Very brief, if I may, Your Honor.
Yes, sir.
The I think the state misses the point with the Harbison case. Those 8 tests are not some form of calculus that you have to check off the list. In fact, in Harbison, you got 3 co-defendants, and it involved a shooting with teenage kids, two people shooting at each other. And in Harbison, Harbison, the important thing to note is that the Supreme Court was talking to the Court of Appeals that reversed the ruling of the trial court in not severing, because the Court of Appeals said that they should be severed. And what Harbison did was said, just from now on, consider these factors. And it repeatedly said, this is not a bright line test. And I wanted to bring that to the court's attention as we're talking about it. It does not have to be some 20 defendant RICO case. There was a 20 defendant or 18 defendant RICO case mentioned in Harbison, if I'm recalling correctly, that was called to 16 at trial, and you did have multiple counts. They were talking about that case, but they didn't say that it has to be a case like this at all. And so I wanted to be clear, it's an abuse of discretion standard in severance. I think that the statutes are, or the rule is a clear rule that basically, is it fair to the defendants that are involved, whether or not they'll get a fair trial one way or the other. And I would just emphasize the fact at this point, in this stage, I'm not saying anybody, and I don't know where Mr. Hagerman is sitting in my head at all on this. There's no plan from me to point to either of the other individuals that came from that first scene. They saw how he was acting. They saw what went on. They saw the strength, and et cetera. And they also had an appreciation for, if you keep holding on to this guy like this, and he has this superhuman strength, he can break loose. He can go get his whatever he might have or wherever it might be, because we don't know enough about what's going on at this point in time. And that was their perspective. That's different than the perspective of the 3 individuals that were at the second scene.
But the conduct that the state is referencing, stating that the conduct of all of the officers is the conduct that took place in the second location. Is that the position? Because your original argument was that they didn't have anything to do with the first location, so
yes,
therefore that they came into something unbeknownst to them. But if the state's position that all the criminal conduct for all the defendants could be established in the second location, how does that not change the position?
Then you're limited to the fact that at the second scene, the defendants are required by law to have engaged in the conduct specifically exactly as they did. They are required by law to attempt to apprehend a suspect that is at that time, in all 3 of their minds, a fleeing suspect that is engaged in an altercation with police. That's all that they know. They don't know anything else about what he's doing, where he's coming from, any of that. And so based on that, and based off of what we do know from the body worn cameras and hearing the conversation, there was no talk of anything punitive while they're attempting to apprehend that suspect. And he, and the state uses the language suggesting it's horrible and X, Y, Z. Well, it's going to be a jury question on whether or not, in the overarching scheme of things, with the amount of time that the person was struck and with the amount of time that the person might have caused a danger to either himself or the other officers that were involved, that based on those split-second decisions, if Bean could have done anything different. And what we're saying is, if that is going to be considered, it should be considered specifically based off of what he knew. And I understand what he's saying about criminal responsibility. In this case, even though you don't use the word, well, they're not indicted for conspiracy, the overarching concept is that there was indeed a conspiracy to have done something wrong, because that's the only way that you can get to the point that if this officer is trying to take a person into custody and the law says that he does have to try to apprehend him and the person does not allow him to handcuff him, that he's doing anything that in any way would bear out criminal responsibility to what ultimately happened at that scene.
Anything else from the council? Anything else
Hagerman, no, this is the same red hard drive.
Before,
Can I pass it to the clerk?
yes.
And Your Honor, while you're doing that, because I didn't know if Your Honor would want to see the videos, and I will tell Mr. Hagerman and Mr. Mulroy that the expert that we have as it relates to the videos and use of force took the freeze frames and the timing to the frame on that video is depicted here. And it goes to Mr. Hagerman's argument about Justin Smith holding him for beating. And so would these freeze frames of that very video be helpful to Your Honor?
I would rather you show the state.
Absolutely. Now, approach them. It's just freeze frames of this video.
If he wants Your Honor to review these particular free frames, that's fine.
I was just offering to the court if it would be.
Small portion.
Yeah, I will look at those as well. All right. I would like the opportunity to look at these videos. Is there any further argument on any of the motions or responses?
No, they haven't been, you know.
I know we have a comeback date of November 6th. I think that it would be appropriate for us to have this matter resolved before that time. I failed to ask you all for appropriate dates. I would like to have a Are you all available Monday, October 2nd?
He said October 2nd.
But not until the afternoon.
Yes. Oh, okay. That is very.
Just a second. I think that, on the 29th is my birthday. I think I plan to come in slow.
I'm available October 2nd, Your Honor, if anyone else is.
So,
Either the second or the fifth.
the fifth is better for me if it's okay with you guys.
Fifth is going to be on the 6th. Order to be entered on this one.
So the defendants need to be there on October 5th.
I'll leave that to you, counsel.
I'm going to ask that Mr. Mills be excused that day.
Same
He
request.
won't be here.
We will show the defendant's presence excused for the ruling. We will show this matter reset for the order to be entered October 5th. Show the report date on November 6th.
Thank you for taking time. Thank you, Your Honor.
Thank you, Your Honor.